all of you, what are the most important things that practitioners should take from your presentations on the subject today? I want to start with Mary Eaton of Wilkie, Farr and Gallagher. Mary?
Hi, thank you. So with respect to ascertainability, it's obvious that a number of key issues remain unresolved, and there isn't any indication that resolution is in the offing anytime soon. And that gives rise, to my mind, at least to three key points. The first is that it is really the rare case where no ascertainability issue can be raised or argument can be made. So the defense counsel should always be considering ascertainability challenges, and that's true not only in consumer class actions, which, as I mentioned, has been the subject of most commentary in this area, but other cases as well. So, for example, some thought needs to be given to it in the securities class action setting, of which there are very few ascertainability decisions. The second point is that, notwithstanding its challenges, I do think that ascertainability challenges should also be assessed even in those jurisdictions that have embraced the lesser, more lenient, plaintiff-friendly standards. There are, in many cases, obvious advantages to making those challenges and to doing so at the outset of the case as opposed to later, and you would be surprised at the number of cases that go forward without those challenges having been launched. And then thirdly, I would say you need to be prepared to defend the heightened standard. If, for example, you're in the Third Circuit or some other circuit that seems to have embraced the heightened standard, because even in those jurisdictions, it's not entirely clear that the issue has been definitively resolved. With the flip-flop in the Second Circuit, which I talked about a bit earlier, and the questions being raised in the Third Circuit, at least by some judges, to be good examples of that. And then ever so briefly with respect to the tolling issue, two things. One is that even though the tolling issue as applied to statutes of repose has been settled, its application in particular cases has not. I think there's a real question in many instances as to whether the legislature intended a time bar to act as a statute of limitation or a statute of repose, and defense counsel needs to be mindful of that. And then secondly, until the Supreme Court rules, which hopefully will happen soon, we should be continuing to make arguments against class action stacking wherever we can. And we should also give increased attention, I would say, as a result, to the utility of making venue and transfer motions to bring cases within jurisdictions where we're going to get a more friendly audience, so to speak. Thank you.
All right, thank you very much. Dr. Armando Levy.
So I would say two takeaways. The first is with respect to price dispersion and that analysis and the battle of the experts, I think to really carry the day, it comes down to what the narrative is that goes with your description of what's in the unobservable part of the model. And if you can tell a story where that is actually a compelling missing piece, that I think you have some leverage for class cert. The second piece is with respect to conjoint or a hybrid conjoint and hedonic regression analysis. The one thing that's missing, weak spot in any plaintiff's expert report that I've seen, is that you need to address the supply side of the market. It's not optional. And that's it for me.
Thank you. Mindy Barfield of Dinsmore and Shoal.
As to the takeaways of the impact of the Wal-Mart case, and has it had the impact predicted, a couple of takeaways there would be, it depends upon where you are and what court you are, and that's true of a lot of things. If you're in state courts in Middle America, which is a lot of the places that I practice, it probably hasn't had the impact that it has in federal courts. It has certainly had an impact in federal courts in some places. In insurance-related cases, there have always been the good arguments that those cases have to be decided on an individualized basis and that there's no common questions that predominate. And Wal-Mart adds to that the argument that could always have been made. And the other takeaway being with regard to Daubert challenges, make them. Courts, it now appears that, as Kristin mentioned in her presentation, it now appears that courts everywhere at least provide some sort of Daubert assessment of experts at the certification stage under some standard, and so as defendants, I would suggest making those Daubert challenges early and often.
And finally, to our last presenter, Kristin McCarran of White & Case.
Thank you. So my key takeaway, and what I hope people came away with from my presentation, is that the introduction of the rigorous analysis standard, raises a serious issue of how to handle the admissibility and persuasive value of expert testimony at class certification under that standard. And this issue is arguably been driven in the context of antitrust class certification, particularly under the Rule 23b3 standard, because of the nature of antitrust cases. And this issue has been bubbling under the surface, if not yet front and center in written opinions. And I think it's an issue of interest, and I think it's one to watch going forward. And my takeaway, I think, as a practitioner, as Mindy just said, and I'm hardly the first person to say this, that it's impossible to underemphasize the need, to fully understand and engage in the battle of the experts at class certification, particularly in antitrust.